demystifying the use of irrevocable trusts for long-term care planning. I'm Suzanne Sayward, a partner at the Dedham, Massachusetts law firm of Samuel, Sayward, and Baylor. And with me is one of our senior associate attorneys, Frank Mulé. And we're going to go through with you tonight what's an irrevocable trust, what is it used for in long-term care planning, and who might this be appropriate for. Keep in mind that irrevocable trusts can be used for other reasons as well, but tonight's program is focused solely on using irrevocable trusts for long-term care planning. So we do have a set of slides which will eventually be posted onto our website with the recording of this webinar. So you will have access to the slides. For tonight, we're going to post them so you'll be able to follow along as we walk you through them. You can ask questions using the chat or Q&A feature, and we'll probably wait and take the questions at the end or answer the questions at the end. Feel free to ask them as they occur to you. So Frank, why don't you go ahead and share the slides? And Frank and I are just going to go back and forth a little bit on between the slides talking about this topic. So Frank's going to start.
Good evening, everyone. So the first question you might have is, why worry about an irrevocable trust for long-term care planning in the first place? And the answer is that the cost of long-term care has been rising for years. It continues to rise, and it is unlikely to stop rising anytime in the near future. So there are three basic types of long-term care. There's what most people think of as long-term care, which is at a nursing home. And as you can see from one of the charts here, the national median cost for a nursing home, for a private nursing home room in 2020 was almost $106,000 per year. And that's quite a bit of money. On the other hand, you can also get long-term care at home through home health aides. The national hourly cost for a home health aide is $24. And if you need round-the-clock care, that can add up quite quickly. And then the other option is an assisted living facility. And those costs have increased by nearly 80% since 2004. And so this is a national picture, but what about Massachusetts? Well, Massachusetts, like in so many ways, is a leader in the cost of long-term care. The annual cost of a nursing home in Massachusetts for a private room is $445 a day, which annualized is over $162,000. So that's more than 50% more than the national average of a private nursing home. And the cost of a shared nursing home room, which is typically what most people get, is $415 a day, which is still $150,000 a year, and still significantly higher than the national average for a private room. On the other hand, assisted living costs in Massachusetts, which can vary greatly depending on the type of assisted living you need, and if you're in a specialized unit for, say, someone with memory issues or dementia, or if you're just in an assisted living apartment, but are mostly independent. But that can range for a single occupancy from anywhere from $2,000 to $7,000 a month. So, and we have a website here that we will include when we post the slides to our site that you can go to calculate and play around with numbers and see what a long-term care cost could be, but it is quite significant, and even people who have saved substantially for retirement, those funds can get eaten up rather quickly if long-term care becomes necessary. So the question is, how do we pay for it? Well, as I said, it's very expensive and it's going to keep rising, and it's not going to slow down anytime soon. And so in Massachusetts, there are three basic ways to pay for long-term care. The first way is with long-term care insurance. Now, this is different from health insurance. This is not Medicare. This is not your private HMO or Medicare Advantage or Medigap supplemental policy. None of those really pay for long-term care beyond short stints for rehabilitation purposes. Long-term care insurance is a separate type of insurance that you purchase usually from a life insurance company, and unless you get really lucky with the policy, it will usually only partially cover the cost. So long-term care insurance is really meant to supplement private pay, which is where you just go to the nursing home or assisted living facility and pay out of your own money. And then the third way to pay is Medicaid, which in Massachusetts is called Mass Health. Medicaid is not unlike Medicare. Medicaid is a needs-based program, so it has certain resource and income eligibility limits that we will discuss as this presentation goes on. But Medicaid is really the primary way to pay outside of using your private resources, either directly or through paying for long-term care insurance. And now I believe Sue is going to talk about what long-term care planning is.
Right. So if you don't have long-term care insurance, or if you are worried that that insurance is not going to cover a significant amount of your care costs, then you don't have the resources to write checks for $160,000 a year without some pain, you may want to think about doing some planning. And there's two types of long-term care planning. Triage planning is when you haven't really done any planning and all of a sudden you're faced with needing long-term care. A lot of times people think, oh, there's nothing I can do about it. I just have to spend down all my money until I reach the eligibility criteria to become Medicaid eligible. That's sometimes true, but sometimes it's not true. So what I want you to take away from this program is, even if you don't do any planning, if something happens and you are facing long-term care, consult with an elder law attorney to see whether or not there are options that you could take advantage of to preserve some of your assets. But really what we're focusing on tonight is pre-planning. So pre-planning contemplates that you are going to take steps to make yourself eligible to meet the Medicaid eligibility criteria sometime in the future. This often involves transferring assets either directly to family members or to irrevocable trusts, as we're going to talk a little bit more about tonight. And when you do that, there is a 5-year ineligibility period. And Frank's going to talk more about this 5-year ineligibility period because it's not as simple as it sounds. The rules changed here probably now 15 years ago, so that really any transfer that you make within the 5-year period preceding your application for benefits is going to cause a period of ineligibility. So timing is absolutely critical when you're doing this planning. So transfers mean giving things away, mean to directly writing checks to family members, means transferring assets to irrevocable trusts. Another way to transfer assets that we mention on the slide is a deed with a retained life estate. We're not going to talk too much about that tonight, but you may be familiar with that concept where parents typically would convey their property to their children or to their child and keep a life estate on the deed. That is the right for the parent to continue to live in the property. We'll touch on that a little bit when we talk about real estate, but that's a topic for a whole different webinar.
Yes, it is.
All right, so our next slide is, good job there, Frank. So what do you need to establish in order to be eligible for long-term mass health benefits? Well, if you are the person who is applying, whether you're a single person or whether you're a married person and there's one person who's applying for mass health benefits, in order to be eligible, you can't have more than $2,000 of countable assets. Now, the next slide or the slide after that, Frank's going to go over what are countable assets and what are non-countable assets. But the person who is going to apply and become eligible for Medicaid benefits cannot have more than $2,000 of countable assets in his or her name as of that eligibility date. We have a note here that a person who's receiving long-term Medicaid benefits is entitled to a personal needs allowance of a whopping $72.80. So this is the amount that someone who is eligible for Medicaid benefits to pay for long-term care may retain out of their income each month to pay for their personal needs. The rest of their income must be paid to the long-term care facility or otherwise used for their care in order to maintain eligibility. Now, if you are a married couple and one member of the couple will be applying for Medicaid and one member of the couple is residing in the community, sometimes that's called the community spouse or the well spouse, the spouse at home. So the spouse at home may keep an additional amount of countable assets. This amount changes every year. And for 2022, that amount is $137,400. So in addition to non-countable assets, the spouse in the living in the home can keep that additional $137,000. Now, you know, you're probably at home horrified thinking about, wow, that is not very much money at all. And no, it's not. So be aware, married couples, that there is planning that can be done to increase the amount that the community spouse can keep. But again, that's a topic for another night. The comment there about the minimum monthly maintenance allowance. I mentioned earlier that if you are the person in nursing home receiving long-term Medicaid benefits, all of your income must be paid to the nursing home with the exception of this $72.80. And you can also pay your personal health insurance from your income as well. But if you have a spouse who's living in the community who has very low income, and you're the spouse in the nursing home and you have a hefty income, you can give some of your income each month to the spouse in the community. For example, I have a situation where a spouse had a very good pension from the Commonwealth. It was almost $6,000 a month. And it was what you might call a traditional marriage where the wife had not worked much. And so her Social Security benefits were very low. So she was able to have a significant amount of his income paid to her each month. So you see that number there. The minimum is $2,177.50 a month. That's a gimme. So if I'm the spouse in the community and I only have $800 of my own income, then my spouse who's in the nursing home can allocate up to that $2,177.50 as a gimme. There's no test for that. I can get more than that, up to $3,435 if I have housing costs and utility costs that I have to pay each month. There are circumstances where the spouse in the community can get even more than the $3,435 a month, but you need to jump through a few hoops to do that and really show that you have care costs beyond that amount. All right, Frank, moving on to countable versus non-countable assets.
Yep. So as Sue mentioned, for Mass Health applicants, there are asset limits related to countable assets. Now, what is a countable asset? At the highest level, a countable asset is basically anything that can be liquidated or converted into cash and then used to pay for your care. So bank accounts, certificates of deposit, mutual funds, stocks and bonds, the value of most real estate with an exception for your house, and even IRAs and other retirement accounts. You will have to pay the associated income taxes if you have to liquidate your IRA, but Mass Health will make you do that in order to qualify and get below the asset limit. There are some exceptions for non-countable assets. The biggest exception would be your house. So if you're a married couple and the healthy spouse or the community spouse is living at home, then the home is non-countable. It doesn't matter what it's worth or anything like that. Mass Health is not going to force the community spouse out of their house in order to get the nursing home spouse onto Mass Health. If you're a single person, there is an equity limit on the house after which they will make you sell or mortgage the property that I will discuss in more detail in a moment. But generally speaking, the home is a non-countable asset and you will not be forced to sell it to go into to get eligible for Mass Health. Additionally, each household is entitled to a single vehicle that you can keep. So again, the community spouse doesn't have to sell their car in order to meet Mass Health eligibility requirements. If you have term life insurance, so life insurance that can't be surrendered for cash, then that is totally non-countable because you don't have access to anything during your lifetime. If you have life insurance that can be converted for cash, so that life insurance that has a cash surrender value, if the death benefit of the policy is more than $1,500, Mass Health will require that it be liquidated or that it count towards either the $2,000 for the nursing home spouse or the $137,000 for the community spouse. Additionally, burial plots are not countable. So if you own your burial plot in a cemetery, you do not have to sell that. You can also set aside $1,500 above and beyond the resource limit for the community spouse or the institutionalized spouse in a savings account that's earmarked for burial and funeral expenses. And again, this does not count towards those asset limits. And lastly, you can prepay your funeral expenses by setting up an irrevocable burial trust or a prepaid irrevocable contract with a funeral home. And as long as that contract meets certain requirements, that will also be a non-countable asset. So those are some ways to preserve value without having to spend down assets on your care that typically come up in the triage planning that we touched on earlier. But
Just
again,
to add one thing there, Frank. So for example, Frank was mentioning your house is a non-countable asset. And if you're a member of a married couple and you have other assets over and above that 137,000 and you have a mortgage on your home, then one easy way to spend down without actually having to spend your money is to apply those excess assets or excess resources to paying down the mortgage on your home.
exactly. And speaking of the home, let's talk a little bit more about how real estate works. So, as I said, your principal place of residence, if you're married and at least one spouse is living there, it's not going to be countable. Basically, no matter what. If you're single, the principal residence must be located in Massachusetts for reasons that will become clear in a moment. And the equity in the home must be below a certain amount. As with the amount that a community spouse can keep, this amount changes from year to year. In 2022 in Massachusetts, the equity has to be below $955,000. If it's above that, then you'll be required to either mortgage the house so that the equity value is below that and then pay the cash to the nursing home, or sell the house. Additionally, regardless of your equity interest, if you have a minor child, a permanently disabled family member, meaning that they qualify for under the Social Security rules for disability, a sibling who co-owns the house with you, or a caretaker child, meaning a child who has provided you with a level of care that prevented you from going into a nursing home for at least 2 years, then the house is probably not going to be countable.
One thing I want to just add here. So, Frank's talking about how the house isn't countable if you're a married couple, and that's true, but that doesn't mean that you should not do any planning. So if you're a married couple and one person needs to go into a nursing home and you're doing this on your own, which I don't think is a good idea anyway, but you always want to get some advice about doing this, because if you leave the home jointly owned by husband and wife, and say the husband's in the nursing home and then the wrong spouse dies, meaning the wife gets hit by lightning and she passes away, well, now the house belongs 100% to the husband who's in the nursing home. And Frank's going to tell you in a minute why that's a really bad idea. So you want to, in those circumstances, make sure that you change the ownership of the home to the spouse in the community, and that she then does some planning to make sure that it doesn't go back to the nursing home spouse if she were to pass away.
Excellent point, Sue. And there are 2 reasons to do that planning. First, if your house is worth more than $955,000 and the wrong spouse dies first, then the nursing home spouse is going to have an equity interest greater than that limit, and it's going to turn the home into at least a partially countable asset. Second, even though the home isn't countable per se, and even though Mass Health won't force you to sell it, what they will do is put a lien on it. And the lien will be filed during lifetime, meaning that if the house is sold while the Mass Health spouse is receiving benefits, Mass Health can recover for the benefits that they've already paid. Second, well, they won't force a sale if you check the right box on the Mass Health application, meaning that you indicate that you intend to return home, even if medically it's unlikely that you will. If you subjectively want to return home, they're not going to force the sale of the house. But after you die, the house becomes part of what's known as your probate estate, and Mass Health can recover against your probate estate for the cost of the care that they provided. So when we say Mass Health, that the home isn't a countable asset and that Mass Health won't force a sale, what we really mean is they will defer the use of your home to pay for your care until after your death. But unless you do pre-planning, eventually they will get paid. Now, if you're a married couple and you do what Sue talked about and transfer the home completely to the healthy spouse's name, then there's no, the nursing home spouse has no interest in the home, so there's nothing for Mass Health to put a lien on. And as long as the healthy spouse doesn't subsequently have to get on Mass Health, they're not going to be able to recover against the home. So for a married couple, that can be a way to, an easy way to protect the house as long as both spouses don't wind up needing Mass Health. Additionally, I just want to make one other comment where I've said that Mass Health won't force you to sell the house to qualify for benefits. And that's technically true. But remember what Sue said earlier. Once you go on Mass Health, all of your income, less that $72.80 per month, has to go to the nursing home. That means that your income can no longer pay the property taxes, the homeowner's insurance bill, the utilities, or the general maintenance and upkeep for your home. So if you're a single person and say your kids don't want to start paying those costs out of their pocket because it's got a lien on it from Mass Health, so they might wind up getting nothing out of it anyway, well, they won't force you to sell the home. Effectively, you're going to have to, because after you run out of that $2,000 of countable assets that you're allowed, you're not going to be able to keep up with the taxes and other costs. So there's a difference between being forced to sell the home by Mass Health and being functionally forced to sell the home because you can no longer afford to its upkeep once you're on Mass Health.
Now, they will allow you to rent it. But when I say you to rent it, obviously that means somebody in your family has to take responsibility for being that landlord and managing that rental. And sometimes that can work out pretty well. Again, this sort of goes back to the triage planning. You haven't done anything and now you're faced with this situation. Even though if you start renting your property, it's no longer your primary residence. And Frank will talk a little bit about other real estate, but you can rent it out and the rental income can be used to pay for the costs of maintaining the property. So if you rent it out, it can even be rented out to friends or relatives, but it's got to make a profit. So if it costs, $1,000 a month to maintain the property, you've got to rent it out for something more than that in order for it to be categorized no longer as your non-countable home, but as what's called business property essential for self-support. That is also an exception to that countable asset rule. But you really do have to be making money from it. Otherwise, they've become pretty strict about making you liquidated if they don't really see that this is business property.
Excellent point. And that goes to the last issue I wanted to touch on with real estate is, generally speaking, real estate other than your principal residence is a countable asset, except if, like Sue mentioned, you rent it out and you rent it out for a profit. And that's because it's now business property. And if it's rented out for a profit, then typically Mass Health will consider it to be essential for self-support, meaning that because you're making a profit and because the income is payable to you, the net income above the operating costs is going to go to the nursing home and lessen the amount that Mass Health has to pay. So they're more than happy to allow you to keep it if it's being rented profitably. But rental property is still subject to those same liens that I talked about for the primary residence. So eventually they will come after the principal. The other thing to know, and this, I know this has changed somewhat, but in the past, Mass Health has been hostile towards out-of-state rental property, even if it's rented for a profit. And that, again, has to do with their ability to recover against it, because they don't necessarily have the jurisdiction to recover in an out-of-state probate scenario or place a lien on property that's outside of Massachusetts.
Right. They really haven't. I know of no instance where the Commonwealth has liened out of state property for Mass Health recovery. Not to say they never will, but so far that hasn't happened. So stay tuned.
Yeah. And so now let's talk a little bit about the 5-year look back period. So what this really boils down to is when you go to apply for Mass Health, so you're in the nursing home, you've spent down your assets so that you're at the $2,000 level, or if it's a married couple, you've spent down so that you're at the combined approximately $140,000 level. Basically, from the date of the application or the date that you're seeking benefits, Mass Health has the authority to review 5 years of your financial statements and asset transactions. And what they will do is they will penalize you for any transfer that's made for less than fair market value. So basically a gift or like say you sell your house to your children, but you sell it for way less than it's actually worth. Mass Health looks unkindly on that. They consider that to be a gift. And they consider any transfer for less than fair market value to be a disqualifying transfer. Now, what that means is they're going to assess a penalty on that transfer. And they calculate that penalty by taking the value of the transfer and dividing it by what they consider to be the average cost of nursing home care in Massachusetts. And so the answer to that equation is the number of days that you are disqualified from receiving Mass Health benefits. And what that means is you have to pay privately, except you can't, because the period for disqualification doesn't run until you're otherwise financially eligible, meaning that you only have the $2,000 left in your name. Now, if you're a married couple, you could theoretically use some of that $137,000 to pay through the disqualification period. But if you're single, you're out of luck. And this is the change that Sue was talking about that happened probably around 15 years ago or so. It used to be that the disqualification period ran from the date of transfer. So as long as you made the transfer more than, and then waited out the disqualification period to apply, you were fine. But Congress eventually caught on that people were doing that. And so they changed it to make it effectively impossible to pay through a disqualification period without the help of family or friends.
Right.
Now,
so the old rule that Frank was referring to was sometimes called a half a loaf, which allowed for people to say I have $100,000 and I know I'm going to go to the nursing home. I could give away 50 of that to my children. I would incur a disqualifying it would be a disqualifying transfer, and I would incur a period of ineligibility, which would run from the date I gave it away. Well, I kept 50. So I'm going to use the 50 that I kept to pay for whatever it was, 5 months of disqualification at the time. And then once I got through the 5 months, voila, I was eligible for benefits. But as Frank said, not anymore. Now the period of ineligibility doesn't begin until I don't have any money.
Yep. So as you can see, the 5-year look back period is incredibly important. What is equally important is there are some exceptions. So first off, transfers between spouses never incur a penalty for mass health. So this is why triage planning for a married couple is much easier than triage planning for a single person, because the first step is always to transfer basically everything to the healthy spouse. And then the healthy spouse can take steps to get that down below the 137,000, which is easier to do than getting it down below 2,000. Second, if you have a blind or disabled child, you can make transfers to them, again, without penalty. Additionally, and I mentioned this earlier, if you have a caretaker child, you can transfer your home to their name without penalty. Now, a caretaker child is a child who has lived with you for at least 2 years prior to you going to a nursing home, and for that 2 years has provided you with care that, in the absence of which, you would have had to go to a nursing home. And so if you have a child who can provide care or is willing to provide care, this can be an easy way to help save the house, as long as they're able to provide that care for at least 2 years, and as long as your doctor is willing to attest to the fact that you needed that level of care.
Yeah, Mass Health is pretty aggressive when it comes to making people prove
Yes.
that you have satisfied that caretaker child exception. You know, they make you get letters from the physician, as Frank said, attesting that you needed the care, that you have to get letters that from neighbors or friends or family, or affidavits saying that you actually provided it. You need to produce evidence that you resided there for 2 years. So, you know, it's something that, if you're in that situation, you want to start compiling your case as soon as you're there. Don't wait until, okay, mom's off to the nursing home and now we got to try to reconstruct this.
Yeah, absolutely. So why are we talking about the 5-year look back? Well, because the irrevocable trust planning that Sue is going to talk about momentarily is a disqualifying transfer. So this is planning that needs to be done at least 5 years before applying for Mass Health. Otherwise, it's not going to work, and you're going to jeopardize your ability to get the care that you need. And with that, I will turn it over to Sue.
All right, so why use an irrevocable trust for long-term care planning? The reason that somebody would use an irrevocable trust for long-term care planning is because they want to preserve their assets for their beneficiaries, typically children. Because using an irrevocable trust for long-term care planning does not benefit the person who is doing the planning, other than to maybe provide peace of mind that you've protected the asset for the benefit of your children. But it can actually foreclose some planning options that you might otherwise have, or some living options, I should say, that you might otherwise have. You know, one of my favorite sayings to my clients is, money buys you options. When you have money, you can choose how you want to live. Do you want to stay at home and have people come and take care of you? Do you want to move to a fancy assisted living place? You know, do you want to build on to your kid's home and live there with caregivers? So if you have money, you have options. If you don't have money because you've given everything away, then your option is to go to the nursing home. So just keep in mind, this is what the reason for this planning is to protect the assets for someone else.
is an important point.
All right, so now let's sort of get to the meat of what is an irrevocable trust. Essentially, think of an irrevocable trust as a trust into which you will transfer an asset that you can no longer get back. So you can retain, whoops.
Sorry.
That's all right. You can retain certain rights over the irrevocable trust, but you can't retain the right to get the asset back. So in the broadest sense, when you create an irrevocable trust, first of all, you cannot or should not serve as the trustee. So if you're used to doing estate planning and familiar rather with doing estate planning, and you might have a revocable trust or a living trust as part of your estate plan, and you serve as your own trustee and you control the assets and your name is on the checkbook and all of that. That's not how an irrevocable trust would work. Someone else would be the trustee. Often people have their adult children serve as the trustee. Now, you as the grantor creating the trust can reserve the right to remove and replace the trustee. And you would certainly want to do that. In case you name, one kid and she starts giving you agita, you can get rid of her and put the other kid on. So because they're the ones who are going to be making decisions and transacting with the assets in the trust. You can receive the income from the trust only. And in this context, income means interest and dividends, basically. Now, one of the most common assets that people put into an irrevocable trust is their home. And the reason for that is because you don't have access to it, to the assets in the trust, people are reluctant to put their money in there. They don't want to put their investment account in there. They don't want to put their bank account in there because then they don't have access to those assets anymore. But you can put your house into an irrevocable trust and you can continue to live there. You can even continue to pay all the bills just like you were doing before. So it doesn't really change your life. And in that circumstance, there's no income, right? It's your home, you're living there. It's not generating any income. But the house could be sold. People often say, oh, you put your house in a trust and then you can't sell it. It can be sold. It's just that when it's sold, you can't have the money. The money stays in the trust. And that's where production of income may come into play. So say your house gets sold for $500,000 and now there's an investment account with $500,000 in it. Depending upon how it's invested, you may make, I don't know, $20,000 at 4% a year on that. That's not too much income. And certainly if you said, this is my only asset, and I hope that I would then be able to move to assisted living and pay that $2,000 to $7,000 a month with the proceeds from my home, that's not going to work if your house is in an irrevocable trust, because the principal cannot be used to pay those assisted living monthly expenses. The trust has to be crystal clear that no principal can be distributed to the grantor or the spouse under any circumstances whatsoever. That has to be crystal clear or your trust will fail when you go to apply for those mass health benefits, and the Commonwealth will deem those assets to be countable or available. Now, the trust can have a back door, which would allow for distributions to people other than the grantor, like the children. So distributions could be made to children. The children could choose to use that money to help their parents if they wanted to, but they're under no legal obligation to do so. It's the children's money if it gets distributed. Now, an irrevocable trust for this type of planning is better in many ways than a deed with a life estate, which I mentioned briefly early on, for tax reasons. And there's two types of taxes that we were thinking about here: estate tax and capital gain tax when the house is sold. So you're probably familiar with the tax rule that allows you to exclude $250,000 of capital gain on the, excuse me, on the sale of your personal residence. In order to be eligible to take that exclusion, you must have lived in the home and occupied it and owned it for a period of 2 out of the 5 years preceding the sale. When you do a deed with a life estate where I say, okay, I'm going to transfer my house to my children and I keep the right to live in it, I don't own it anymore. I only own a life estate, which there's a chart, there's a table that says based on my age, what that percentage is, but it's not 100%. My children own a percentage of it. And if the house gets sold as a deed with a life estate, my children, I hope, haven't occupied my home for 2 out of the 5 years. So that capital gain exclusion is only going to be applied to my life estate value, which of course gets smaller every year I'm alive. But if I put my house in an irrevocable trust and I draft it as a grantor trust for income tax purposes, then when the house gets sold, I am treated as the owner for income tax purposes, for capital gain tax purposes, and I can exclude that entire $250,000 of capital gain. So that's super important. The other benefit to using an irrevocable trust, the other tax benefit, is what's called a stepped up basis when someone passes away. So for those of us who have owned our homes for a long time in Massachusetts, the value has increased over that time. So maybe you purchased your home for $100,000 and maybe now it's worth $600,000. Well, if you're a married couple and you were to sell your home, you wouldn't have to pay any tax because you've got that $250,000 per person of capital gain exclusion. But if you were to give the house to your kids and they were to sell it, then they would have to pay the tax. But if you continue to be the owner for tax purposes, when you pass away, the house gets a stepped up basis. And your children can sell the home for that $600,000 fair market value and not have to pay any capital gain tax. So 2 significant advantages to using an irrevocable trust for tax purposes. And lastly, an irrevocable trust, you can keep what's called a power of appointment. That means you can change your mind about who is going to receive the assets in the trust when you pass away. And this is also very important because in my experience in 30 years of doing estate planning and elder law, I can't tell you how many times people have said to me, oh, I'm never going to change my mind about this, only to 6 months later say, I've changed my mind. So you want to be able to keep the right to change the distribution of the assets in the trust via this power of appointment. And what that means is you would in your will say, hey, I created this trust and I retain the right to decide who is going to receive the assets when I die. And I'm exercising that power to say it's going to go here. So very important. Okay, so we just wanted to mention briefly what is a children's trust. In that prior slide, what I was describing is often referred to as an irrevocable income-only trust. And you know, estate planners love acronyms, so we call that an IIOT, Irrevocable Income-Only Trust. That's the most common way of doing this type of planning. But as Frank had mentioned, Mass Health has been very hostile to this type of planning. Now, we will say it's gotten a little bit better over the past year or so, but if you're very concerned about ensuring that your trust is ironclad or that the legislature doesn't change the rules after you've created your irrevocable income only trust, then sometimes people will do what's called a children's trust, which is basically you've given the assets to your kids. You've simply done it in a trust to keep them from cashing it all in and going to Foxwoods and putting it on red. Right? So they're going to take it in this trust where they're going to have to hold it there during your lifetime. But you're not a beneficiary of this trust. Your children are the beneficiaries. You've given up all strings to these assets. So if you ever needed to apply for Mass Health after the 5 years, you have no nexus. You're not a trustee. You're not a beneficiary. You're not entitled to anything. So this is a super guaranteed way to make sure the assets in the trust are not considered your assets for purposes of your eligibility. It gets a lot trickier in terms of those tax attributes that I mentioned earlier, because if you draft this in a way that says, oh, wait, I am still going to be the owner of it. Well, now you're back in the Mass Health realm where they're saying, well, wait a minute, you do have some ties to this trust. And so now we are going to try to pull it in. So, but just something to be aware of, that sometimes people will create this type of trust. Okay, so what are the advantages to using an irrevocable trust for long-term care planning? To summarize here, so it protects your assets from having to be spent down. And maybe that's important to you even during your lifetime. So after the 5-year period, you could become eligible, assuming your other assets are down to the program level, you could be eligible for long-term care, and you could have this little nest egg over here in this trust that you could have income from, or that distributions could be made to your children. So if they wanted to, say, use the money to help you in some way, get some type of therapy or care that you were not getting because you're on Medicaid, well, here's a little nest egg over here. It allows you to be eligible for long-term care after the 5-year look back. It protects your home against that Mass Health lien that Frank talked about. So if you put your house into this irrevocable trust after the 5 years, Mass Health they can never put a lien on it, but after the 5 years, it's a non-accessible asset, non-countable asset, and it's not subject to that Mass Health lien. You can control the ultimate beneficiaries of the irrevocable trust. Even though it's irrevocable, you can't get the asset back, you still retain some control. You can have the income from the trust. You can remove and replace the trustee, which really gives you a lot of control. And you have those favorable tax attributes that I mentioned earlier. So those are the advantages of using an irrevocable trust for long-term care planning. And if you're considering doing this type of planning and you're thinking about the deed with the life estate versus an irrevocable trust, the irrevocable trust has some significant advantages as listed there. But there's some downsides too. And Frank's going to tell us about those.
Yes, there are. So at the top of the list, as Sue mentioned, Mass Health has a history of very aggressively reviewing and challenging applications that include irrevocable trusts. For a long time, if you had an application that included an irrevocable trust, it was basically guaranteed to be denied and force you to go through appeals, which are time-consuming and expensive, and there are no guarantees. That said, over the past year or so, the Massachusetts courts have finally started issuing some, shall we say, strongly worded guidance to Mass Health about what they can and cannot challenge these trusts for. There are no guarantees, and Mass Health still does go after trusts that it sees an opening for, but they have gotten less aggressive than they had been in the past. They've gotten more aggressive about other things, but that's a topic for a different seminar. Another disadvantage is, as the name implies, irrevocable trusts are irrevocable. Outside of that limited power of appointment that Sue mentioned a little while ago, once you set up an irrevocable trust, you can't change it. And in fact, especially for trusts designed for Mass Health purposes, we purposefully restrict any ability to change it, because an ability to change it is a hook for Mass Health to come in and argue that the trust is countable. Why is this a problem? Because the law can always change, and as we discussed, it has changed in the past, within the past decade to 15 years. So it's always possible that you could create an irrevocable trust now that fully satisfies current law, and then 3 years from now, the legislature changes the law on what's allowed, and all of a sudden the trust no longer passes muster. Now, this is part of why we include the back doors that Sue talked about previously, where we can distribute assets to your children and they can either then give those assets back to you or use the assets to pay for your care. But they're not, we can't legally require anyone to do that with those back doors. So there's always a chance if we create a trust now and it's good now, it might not be good by the time you need to go on mass health, and there might be very little that can be done about it at that point. Additionally, as Sue mentioned earlier, when you give assets away and lock them in an irrevocable trust, you're limiting your future options. If you need at-home care or assisted living, both of which are much harder to get covered through mass health than a nursing home, you may not be able to afford it. You may have put your house, which may be your primary asset, is now in the irrevocable trust, which means you couldn't do, for instance, a reverse mortgage to tap into the equity, and you couldn't sell the house and then use the funds to pay for an assisted living. Additionally, if you do wind up needing to go into a nursing home and you've got an irrevocable trust, you're basically consigning yourself to what mass health will pay for, which means a semi-private room, meaning you will have a roommate and you won't have control over who that roommate is. If you didn't do a trust, you could theoretically access your funds to pay for a private room or pay for a really swanky nursing home that doesn't take mass health. So as Sue likes to drill home for clients considering this type of planning, keeping money in your names keeps the options open. Putting it in a trust can close off some of those options. Even when the trust has backdoors, and even when you have the ability to, say, disinherit an uncooperative child to try and get them to do what you want with the trust funds. Additionally, particularly for married couples, there's a lot that can be done with triage planning, and setting up an irrevocable trust may make triage planning harder and may make you ineligible for benefits that you otherwise would have been able to access with proper triage planning. As I hope we've been hammering home, when you put assets into a trust, you give up unfettered control over those assets. So if we have a backdoor situation where you could have the trustee distribute money to your kids, who could then either pay that money back to you or use that money to pay for your care, first of all, they're not legally required to do so. So once the trustee gives the money to your children, it's your children's to do with what they want. And if they suddenly decide that they don't want to actually help you, they want to go to Foxwoods and blow it all, they can. Also, if your children have creditor problems, if they get into a car accident or are the subject of a lawsuit, they may not be able to help you even if they want to, because if they were to get a distribution from the trust and then pay that money to you or use it for your benefit, that could be considered a fraudulent transfer and land them in all kinds of trouble with the courts. Additionally, not all assets can be transferred to an irrevocable trust. Retirement accounts cannot be directly transferred to an irrevocable trust. So if the bulk of your assets are in IRAs or other tax qualified retirement accounts, the only way to get them to an irrevocable trust is to first make a taxable distribution to yourself and then transfer that money into an irrevocable trust. But depending on the size of that distribution, you could be spending up to 40% or more in taxes. So irrevocable trusts are really dependent on the assets that you have and what you're trying to protect. As I mentioned, if you have an irrevocable trust, it is very hard to access the equity in the real estate. It's not necessarily impossible, but now it's the trustee who will be tapping into the equity and applying for the loan, not you. So loans for irrevocable trusts are typically much less favorable in terms of interest and that sort of thing and other terms compared to loans to an individual. And reverse mortgages, while they might be somewhat possible to obtain, are much more difficult to obtain if the property is in an irrevocable trust. And speaking of mortgages, if there's a mortgage on your house that you want to transfer to an irrevocable trust, that creates its own set of problems. Not least of which is, if you continue paying the mortgage yourself, part of that could be considered an ongoing disqualifying transfer because you no longer own the house, but by paying the mortgage, you're paying towards the principal of the house. And Mass Health could argue that, well, you're making gifts effectively to the trust with each mortgage payment. And so that starts a whole new 5-year clock every time. The long and short of it is there are great reasons to set up irrevocable trusts. There are also great reasons not to set up irrevocable trusts. And everyone hates this, but lawyers love saying it depends. So if you're interested in it, you should speak with a lawyer at length about the pros and cons as they apply to your specific situation.
Perfect. Thank you, Frank. So that's our last slide. Is it right for you? It depends. So, we're happy to chat with you about this if you would like to. Don't hesitate to reach out. But why don't we we have a bunch of questions, it looks like. So why don't we go ahead and answer your questions now? Frank, I was going to say, do you want to stop sharing? So let's see. I'll take them the order. We can start in the order they came in. Are there exceptions for caretakers living in the home that are not children or relatives? So there's no, the caretaker child exception is a child. It has to be a child. It can't be a grandchild or a cousin or anything like that. Now, there is another exception for transferring the home to a sibling who has had an equity interest in the home for at least a year. That has nothing to do with caretaker. So if you owned a house with your sibling and one of you needs long-term care, then you definitely want to talk to a lawyer about doing some planning to protect the house.
I would say there might be a new exception with Mass Health recently revised when they will try to recover after your death. And it used to be that unless you did the caretaker child, if you had to do the caretaker child transfer during your life, you couldn't wait until after death and leave the house to the caretaker child at that point. Mass Health now is saying you can do that. And interestingly, their proposed rules on it are broader than child. It might not be limited to a child. I don't know that I would bet on it personally if it were my house, but yes, the regulation is unfortunately very, very strict, and it has to be a child.
Right. So, and you want to be careful about that. And then this is tricky planning too. So you definitely want to get some counseling about how to do this, both for your long-term care planning and also, if you have more than one child and one child is the caretaker child, but you really want the house to go to all the children, that can create a challenge as well. But I had that situation that Frank was describing it was about 8 years ago now, I think, where the daughter had been living in her family homestead that had been in the family since something like the 1900s and taking care of her parents. And she says she talked to Mass Health and they told her, oh, don't worry about it. The house will be yours. You don't need to do anything. And she did nothing. And then mom was on Mass Health and died, and they ended up losing the house. It was a very, very sad situation. This was not a wealthy family, and so it was bad. So it's good that they're loosening up a little bit. Okay, so is there a time frame you can or can't transfer the house to the community spouse? Frank, you could take that one.
No, it has to be before you get the determination letter that the nursing home spouse has qualified for Mass Health.
I think you have like 60 or 90 days after that to make the transfer.
But you could theoretically do it the day after they go into the nursing home.
Right. How are annuities valued for purposes of being countable assets? Well, they're valued at their, so there's two different types of annuities, right? So if we're talking about a deferred annuity where you have a bucket of money, that's valued at what the face value that's on the statement is. If it's a immediate annuity where somebody is getting a monthly payment and you can't do anything about that, that's annuitized, then it's not considered an asset, it's considered income, and that's income that you would have to pay each month toward the cost of your care.
Yep. Basically, it goes to, can it be converted into a lump sum of cash? If so, then it's whatever that conversion value is.
Is there a way to prevent a second out-of-state home from becoming a countable asset? That's a really good question. And that is certainly planning that we look to do ahead of time. That would be, maybe something you would want to transfer 5 years in advance. Whether or not you can make it business property essential for self-support by renting it out. I have had some luck with that, but I have heard from colleagues as well that they are really cracking down on that too. So this is one of those questions, I think, where there's not a firm answer. It's going to be, well, sometimes it works, sometimes it doesn't. Certainly you could, again, transfer it in advance is a good way to do that.
Yeah, I think transferring in advance is the best way to prevent out-of-state property from becoming countable.
There's also, sometimes say you buy a piece of property with someone else, not your spouse, but you legitimately buy this property together, or you've transferred into joint names more than 5 years ago gratuitously. And then one of the owners wants to or needs to apply for Mass Health. Well, people have had some pretty good luck with a just say no. So the co-owner says, no, I won't sell it. And there's some funny stories from some of our colleagues who, when applying for Mass Health, they've been told, oh, your mom's life estate in the second home she owns in Florida is a countable asset. So this lawyer actually wrote an ad that she posted on Facebook. I mean, not on Facebook, on Craigslist, saying, for sale, life estate interest of an 89-year-old woman in a condo in Florida, blah, blah, blah. And, just said to Mass Health, I didn't get any offers. I tried to sell it. They do let you try to sell things and you can still be eligible. So, it's worth looking into if you find yourself in that situation. All right. Can you still remain in the house while renting? I'm not sure I understand the question. So if you're living in your home and you have like people who live there and pay you rent, so you're not in a nursing home. So,
yeah.
So I'm not, if whoever posted it wants to try to clarify that, you can do that. But I'm not sure it would come into play, because if you're living at home, then you're not in the nursing home.
Right, and I don't know what the rules are on, if you're living in the home, Mass Health isn't going to make you sell it. Like if you're
Right.
trying to get on community-based Mass
Benefits.
Health to pay for home health aides or something, they're not gonna force you to sell the house, as far as I know.
Right. What are the rules regarding the length of marriage? How would that work regarding the 5-year look back? Does it mitigate the single person penalty and allow transfer of an asset to the relatively new spouse? That's a really good question. And oddly enough, when we're doing sort of triage planning, getting married can be one of the things that you do so that you can transfer assets. On the flip side, sadly, getting divorced is also one of the things that sometimes is done to have a to get qualified, or similar to the point I had mentioned before about the income of the nursing home spouse being able to be allocated to the spouse in the community. So I had a case where the nursing home spouse had a very high income. Wife in the community did not. So we actually went, and these were really fairly young people. She still had a mortgage and a car payment and all of that. So we ended up going to the probate court and filing a petition for separate support. So they didn't actually get divorced, but it was sort of like a pre-divorce thing. And we got an order from the probate court that all of his income, which was like $6,000, had to be paid to her every month. And Mass Health had to respect the order from the probate court. So yes, marriage and divorce or other types of family law actions can come into play in this type of planning. Do all irrevocable trusts have to file an income tax return? Well, only if you have income.
Right.
And, to that point, if you have an irrevocable trust, that's a grantor trust. So I create the trust. I'm deemed to be the owner of it for income tax purposes. Theoretically, you don't have to file a separate return, but for Mass Health purposes, I would always recommend that you get a separate tax ID number and you file that separate return, because otherwise they are going to be confused and they are going to say that is your asset because you didn't file a separate return.
Yeah, for Mass Health, even though if it's a grantor trust, you don't need to file a separate return. You want to show as much as you can that this trust is a separate entity that has its own property and its own taxes, and that you're not just commingling assets, for lack of a better word.
Right. All right. The question, that questioner said she had to go, or he had to go. So they we'll have to circle back with them. All right, so people are checking out. Okay.
When Mass Health changes rules and laws, do the changes get grandfathered?
Great question.
Not usually.
Yeah. So there's different ways that things happen, right? There's the
Yeah.
legislature. So they change the law. It's not always grandfathered. No, this is one of those areas where it's not always grandfathered. I will tell you that twice in the last 20 plus years or so, the legislature tried to change the law to that would have affected deeds with a life estate, and sort of made those all available and lienable. And there was such an uproar from both the elder law community and seniors in the Commonwealth calling their legislature and saying, I have had my life estate deed for 20 years. I can't believe you're trying to do this now. It all went away. So that's happened twice. But, I think we're all aware that when times are tough, the places they look for money are the poor and the vulnerable. So those are the programs that they try to get money from. So maybe sometimes grandfathered, maybe not.
I would say, to the extent it is grandfathered, it's usually if you're an existing recipient of Mass Health and they change the rules about trusts, they're less likely to go back and suddenly kick you off. But if you did a trust or did a life estate transfer 5 years ago, and then But by the time you have to apply, the law has changed, then you're probably not grandfathered.
Right, right, because it's the law in effect at that time. How does a reverse mortgage impact an irrevocable income only trust for primary home? Well, if you've already got the reverse mortgage, and now you want to transfer it to an irrevocable trust, I think that could be a problem. I think that could really be a problem. I don't think you can do that.
There might be a way, but it's complicated. You need to.
You would definitely need to work with that lender. Yeah. I mean, my experience with reverse mortgage lenders, they're really pretty rigid. You know, like what I found is when somebody passes away, they're like, okay, we want their money. You know, so I think that would be a problem to transfer the property subject to reverse mortgage without having explicit permission from the lender. I think otherwise you risk having the loan called. Okay, so an irrevocable trust is good for people needing to go to Mass Health, but not necessarily for those who have long-term care insurance and hope to pay for care. Yeah, I mean, that could very well be the case. Another way to think about this too is if you have resources and you have long-term care insurance, most long-term care insurance these days, well, older policies might go on forever, but many policies have a limit for how long they'll pay. So if you have the resources and the coverage, one very good strategy is, all right, I'm going to need the care. I know I have resources in this insurance that's going to cover me for the next 5 years. So I'm going to transfer all my assets to an irrevocable trust now. I've got the coverage for the 5-year ineligibility period. And then at the end of the 5 years, I can receive benefits. So that's not a bad strategy.
The other thing I'll just mention quickly about long-term care insurance is if your long-term care insurance policy meets certain requirements that we don't have time to get into tonight, then Mass Health will not put a lien on your property. They will, because their view is you've done the right thing by trying to help pay for your care. So if your long-term care insurance meets certain requirements, the real estate liens for your primary residence will no longer be a factor.
Right, good point. Can you see that next question? I think
we have I think a clarification about the rental. If there's a community spouse, can they live in the house and also have it be rented out?
Oh, yeah, I don't think that would be a problem.
Yeah.
And then the community spouse can just could keep the rental income.
Right.
Okay, so. Will you do a Zoom call on the problems with long-term care policies and what to do to get them to pay? You know, that's a good program. So we in fact we have someone lined up to, well, we're going to really talk about reverse mortgages, but we can maybe couple that with long-term care insurance. We've done that in the past, and it is a really good program. So yeah, we could resurrect that for one of our Smart Counsel presentations and have someone who is an expert in long-term care insurance talk about that and talk about those issues with getting payment. And I know that definitely happens, and it's frustrating.
Yeah. And then looks like the last question, will Mass Health collect from the policy in the end? Will that be their penalty? So the way it will work is if you've got long-term care insurance and you're in the nursing home and you qualify for Mass Health, the long-term care insurance is effectively considered part of your income. So it will be paying out to the nursing home. And what that ultimately means is Mass Health is paying less to the nursing home than they would if you didn't have the long-term care insurance.
Right, right. And then somebody asked, will you be having a reverse mortgage seminar? Yes, that's what we were thinking of doing. We were almost going to do that this time, but we'll do it a little bit later. And then someone was looking for triage planning. Yep, that's also something that we can that we could do a program on. That's a good idea. I think we've probably done those in the past, and certainly we can resurrect that.
Absolutely.
So I think that's all of our questions. Thank you, everybody, for attending. We really appreciate it. We hope to see people in person, but frankly, everybody wanted to come by Zoom, so that's okay too. I hope you all enjoyed your own snacks at home, and you know, keep watching your email, and we'll keep you posted on what we're doing. Have a great night.
Thank you, everyone.
Bye now.